Good afternoon.
Good afternoon,
How are you?
Chief Justice and Commissioners. I'm, well, a bit nervous, but I'm good to go. Thank you. Thank you very much.
Don't be nervous. You're an attorney.
That is correct, Chief Justice. I've been an attorney for 31
years.
and a few months. That's
My
correct.
goodness. That's a long run.
Yes.
Running a practice in your own account.
Yes, I've run my practice for my own account since 1993, since the day I was admitted as an attorney in December 1992.
Okay. Before that, you studied law, of course.
Yes, it was a bit of a long journey before I got to actually being admitted. I was first at the University of Cape Town. I did a few years with them, and then I got married. And then love was above the law, and I then, and then I took a break in studies. Then in 1985, I then entered into what was then, it's no longer the position, the long-term 5-year contract to allow one to study and do what was called articles of clerkship. That was the terminology back then. And then I did it with a firm in 1985 to 1986. It was a volatile era in our political history. I did a lot of the criminal matters, a lot of the public violence cases. And then I fell pregnant in 1986, and that was a break in my articles. The pregnancy meant a lot to me because I had a previous miscarriage and I really wanted to have this baby. And then I did not proceed and complete the remainder of my period, which was, of course, another 3.5 years left on that contract. But more importantly, by the time I got to 1990, I was itching to get back into the profession. So it's been a long journey. Also, no condemnation was allowed back, at that time. The law societies, the rules were very different.
Yeah. And you had a BPROC from UNISA and a certificate in labor law in your pocket by then.
Yes, I then, I achieved the UNISA BPROC degree, and then I did further certificate studies and advanced diplomas to sharpen my toolkit.
You're an arbitrator?
Yes, when I was placed on the panel with the Road Accident Fund, it was very important for me to understand because then it was not litigation. Remember that the Road Act personal injury law had changed from the token system, the litigation system, to the arbitration pilot project, and I needed to be able to have the necessary skill set, I believed, although I was the panel attorney, as to what it needs to be an arbitrator. And I'm very thankful for that experience because through that experience, I attended an international arbitration in a RAF matter in the Czech Republic.
And you have a certificate in disability medicine from a university I've never heard of. Where is Marshall University?
Sorry, Chief Justice, it's Marshall University in the United States of America. Those who do personal injury law are familiar with disability medicine. And that was also because of being a panel attorney at the outset of my career in personal injury law for the defendant. Often we needed to meet with counsel, and I wanted to be fully au fait with what the medical terminology meant and the disability consequences and the sequelae. So it gave me that competitive edge to read medical legal reports quite quickly. Although I come from a family of medical people, I wanted to ensure that my medical negligence and my medical law was up to notch.
Yeah. And you have many other certificates as well.
Yes.
Including one in mediation.
Yes, several in mediation. They were because I was placed on the land reform management panel to render legal services. And again, I ensured that I was fully qualified for that position. I also, I was very happy that being on that panel, And me having had these certifications, as well as my mediation and arbitration experience, allowed me to train other service providers on that panel for the Western Cape. It was held in Cape Town, and I did it more than once. In terms of further mediation, yes, I've also done PABASA quite recently, and that stems from my one appointment that I had at the Gauteng High Court, where my role was mostly opposed Rule 43 applications and contact and care. And I thought, again, let me quickly, I'm a daughter of a teacher, so I'm always going to be learning. And I did the PABASA. It was an international mediation course on family law. That was the most recent certifications I did, besides other leadership courses with the Nura Women's Institute in Indonesia, where I passed with distinction in July this year.
Good, congratulations. You mentioned that you've chaired the tribunal in heritage, and I see you've listed 2 heritage bodies here, the Heritage Western Cape and Cape Heritage Trust. Are you referring to those 2 bodies?
No, Chief Justice.
Where were you dealing with these appeals?
Yes, so there is the National Heritage Resources Agency Act, and that is to restore the culture and heritage of our peoples of South Africa. And because I had a very keen interest in it, Chief Justice and Commissioners, you might have noted that I enrolled for an oral history, master's in oral history at UCT in 2011, because I was always fascinated about people telling their story. And I was also cognizant that there were still so many stories to be told about South Africans and our indigenous people. So that then saw me being nominated to the board of Heritage Western Cape. So that's a board which, council actually, which sees to any appeals in the built environment. So if a structure is older than 60 years, whether a developer could build and they would then necessarily have to seek the permissions from Heritage Western Cape. It's not just about the built environment. The one matter that I included, and I will get there now as Chief Justice, is about a natural resource where I had to make the determination regarding a natural resource and the right to housing. So going back from Heritage Western Cape, I was soon elevated within the council to serve on its appeals committee. And because I'm a lawyer, I fitted, the job just suited me so perfectly. And then the opportunity was that the Minister of Arts and Culture, it was called then, it's now Sports, Arts and Culture, advertised a position for a tribunal member for heritage appeals directly to the Minister, when in instances where Heritage Western Cape's decision was against an applicant. So I held that position for quite a long time. I've learned a lot. I've always sat as the tribunal chair in that position. I think it's probably 8 years that I served the Minister as his tribunal chair then. And I would sit with an architect, as well as either a historian or a cultural historian, depending upon the nature of the dispute. And one of the judgments which I have included in my pack, I know that the requirements were for at least 3 judgments, but I thought it was very important for me to include this quasi-judicial function that I had as a tribunal chair. A very important case, and commissioners are welcome to ask me questions about it. For me, it was a very important case. In a nutshell, it was a decision to develop housing for low-income socioeconomic groups on the Cape Flats. However, for me, it was the area concerned is regarded as the food basket of the Western Cape. It's where all our greens come from. But under that agricultural land is a natural aquifer. And I could not have heard this matter at a better time than during our drought in Cape Town. And I had to balance those interests of the right to housing and providing housing, which is of utmost importance to citizens of South Africa. However, I had to balance that as against this natural resource, an enduring resource. And in my mind, when I wrote that judgment, it was purely that find land elsewhere. That was my message in a nutshell.
Yeah. Your practice is a general one.
That is correct. I'm very much like a doctor that sees patients with different ailments, and I think that's the best way to describe it. From the outset, when I started in 1992, given my experience in criminal law, remember when I did my articles of clerkship, I did a lot of criminal matters, and so when I opened my practice, I was then able to continue doing such work. But work was non-existent for, one didn't have paying clients. To pay Rihanna Khan Parker in Grassy Park, out in the southern suburbs. So I had to enroll with Legal Aid Board, that's what it was called then, and I rendered legal aid work, family law, legal aid matters on criminal briefs, for almost 10 years of that practice. During that time, though, I did have some insolvency matters because the law firm that I completed my articles of clerkship with was Canterfielke, Frank and Roop, and they did a lot of commercial work as well as a lot of insolvency law. So in the period between 1993 and 2006, I picked up some insolvency matters, which I brought to the High Court, and my practice was very general, doing absolutely everything as I do till today, including intellectual property law, although I am not a patent attorney.
You've acted in the High Court since 2004.
Yes.
Mostly in this division to which you're applying now.
Correct, Chief Justice. I am grateful to an organization, a democratic organization called the Black Lawyers Association. At the time, I was a good friend of the retired Judge Yakiso. And he nudged me and said, you need to be on Black Lawyers Association. And of course, I then did so. I was first the secretary in the early years, and then I became the chairperson 2002 to 2003.
The first woman.
When the first woman, now I don't know, Christine Kunta might have been the first woman before me.
Oh, yes.
Yes. So what then happened was then I got the invitation from the JP at that time to come and act, which I did. I welcomed it, and I did my stint for one term only. I did a fair amount of work, 2 criminal full trials, criminal appeals, and a few civil matters besides motion court and opposed motions.
You were once in the Gauteng High Court, but the period that's listed here totals up to 4 days. What were you doing there?
No, I was invited. Thank you very much to the Judge President for inviting me to come and assist with the burden of the civil court at that point in time. And I happily, again, accepted the invitation, and I agreed to do it pro bono. I was allocated 1 week to do it, although the dates are stated there as being 22nd, 23rd, 24th, 25th, and 26th. My first matter I heard was on the 22nd. I've got it here, the printout. However, the one matter which became a reported judgment in 2019, sorry, let me just get it out, please. Yes, so I was invited to do the week, and I then did opposed motions, more particularly 5 opposed Rule 43 applications, or 4 opposed Rule 43 applications, as well as a contact and care matter. It's the contact and care matter which I then finally heard on the 1st of December. Shortly after that, I contracted COVID, and I kicked myself because I really wanted to deliver that judgment swiftly. I did, however, deliver it within 14 days. It was delivered on the 14th of December 2021, and it is a reported judgment that I've done in that court. That was done virtually from the comfort of my chambers in my office. I was
So you
sworn
do
in
have a
virtually.
reported judgment?
Yes, I do.
How many?
I've got 3 reported judgments. Yes, I regret that when I had applied for this position, I did not have all that information before me. And hence, when the question arose as to how many judgments I had been reported, at that time, I could not find this particular one. I managed to locate it, believe me, Chief Justice, a day after I submitted my application form. It's case number 1326 of 2020. That's the matter in the...
What was it about?
That was about, I gave a judgment on the voice of the child and the parenting coordinator. I must just admit that after 2003, I didn't do much family law because I was largely seized with the road accident fund matters. And I had somebody in my office that would do my family law matters pretty well. So that was my first challenge that I really had, to write that judgment. And I wrote it, and it became reported. I can deal with the other 2 reported judgments if you would like me to talk about it now.
No.
Okay.
Your last acting stint was ended just recently in September, in late September.
No, Chief
You've
Justice.
listed,
I've been continuously acting. Gosh, now where's the periods here?
Oh.
Yes. I was
April.
invited. I was invited by the acting judge president to come back. To the division. That was on the 17th of July, 2023, to the 15th of September, 2023. All those periods then are in the pack. I then did, that was a full term. I then did a half term from the 2nd of October 2023 to the 3rd of November 2023. The reason for that is because I discussed it with the acting judge president that I needed to get back to practice because December is a time where I needed to, my focus needed to be in the practice. So I'm very happy that the acting judge president gave me the opportunity to do what is called a half a term. I then was re-invited to come back on the 15th of April, 2024, and today I am still acting Chief Justice.
And that I count about 9 months for the entire...
It's about 4 terms, 4.5 terms. I've not included my ad hoc week, and I've not included Judge President Mlambo's 1 week.
And I imagine that you've sat in all the courts, civil, criminal, trials, appeals, motions.
Correct, Chief Justice. I've had the good opportunity to sit in all the divisions, criminal and civil. I've also done the pre-trials, the backlog court role in terms of Rule 46A applications. Yes, I've done pretty much everything.
Have you conducted trials to finality?
Yes, I've done trials to finality, probably about 6 of them, Chief Justice.
How many criminal?
Criminal trials, I've done in total across the periods 2 full criminal trials. The one that's in my bundle is a very earlier one. It was a reportable judgment which I did on the minimum sentence. The Waterboer one, I apologize that it's in English and it's called Water Farmer there. That's because on SAFLI it was in Afrikaans, and I thought, let me rather just get the SAFLI has a provision there where you can type in what language you wish the judgment to be printed out in, and I then printed it out in English. So that was the one criminal matter, and I did another criminal matter The second criminal matter, which I did in 2004, went on appeal, but my decision was upheld.
Oh, good. So, apart from these 3 reported judgments, you mentioned how many other written judgments?
To date, as I sit this morning, another one went out, so I have 48 judgments that I've done. The bulk of it has been done, I would say, from April 2024 to date. The 2 reported judgments I've picked up in August and September relates to judgments where I was able to deliver the judgment. For example, the one was, I heard the matter on the 3rd of August. On the 8th of August, I delivered that judgment. That became reported. The other judgment I delivered on the 29th of August. It was on insolvency. I delivered it on the 5th of September, and that was also reported. And there are other reportable judgments which I'm following up to see, where they are in the system.
The GCP seems to have you all wrong because they raise a concern that you have little acting experience and you have written only 4 judgments. So I'm surprised when you mention 10s now. What do you say to this criticism? Because it leads to a damaging conclusion that because you have this, or you have only 4 judgments under your belt and little experience in the High Court, it is not possible to assess your proficiency in law.
But with all due respect to the General Counsel of the Bar, if they had read my full application, which I had submitted as part to the JSC, they would have seen a list of judgments which I did include, which were 25. That was the list of judgments that I could gather, and I think it's on page 33, if I'm not mistaken, of my bundle. I'm not sure. It's a list of judgments which was accompanied in my application. If Chief Justice can just give me a few minutes, if I can just check where it is in this bundle.
We don't have a few minutes, Ms. Parker, unfortunately.
Okay, be that as it may, I did annex it. It's in my application form that I attached a list of some judgments. There were 25 listed. So I couldn't understand when I saw that comments from the GCB. Yeah. And it just didn't make any sense that I would be shortlisted on just 4 judgments.
You're a gender activist.
Yes.
You're involved in a number of bodies that have to do with the promotion of women's welfare.
Oh, no, absolutely. It comes second nature to me to use my voice at every seat, at every table that I am at, to look at the composition of boards and councils. And that's borne out purely because of my own struggle to get work. It's born out of the pleas of women, born out of people that have left my practice, and my colleagues who complain that despite them having the necessary specialization, they just do not get the paying briefs. So I use my voice wherever I am. For example, I serve on the Legal Aid South Africa. Yes, I've come full circle from being a panelist for Legal Aid in 1993 to 2003. I then became a Legal Aid panelist again in 2022 to 2023. And when the opportunity became available to serve on its board, I applied and I was successful. At that, in our meetings, I would interrogate, for example, the briefing of our practitioners on our adjudicator system. I would ask them for the statistics. And because legal aid is regarded as the flagship of access to justice for South Africa, they really could produce pie charts and bar diagrams with regard to the gender splits, because it is something that I watch very closely. And that is borne out by the statistics in the profession that troubles me. Today, as I sit here, the last figures that I have before me tells us that we've got 36,000 legal practitioners in South Africa. That includes advocates and attorneys. However, when we look at the gender split, you see that the figures don't make any sense. 14,000 of that 36,000 are women, and 21,000 are men. If you break that further down into, black, colored, Indian versus white, black, colored, and Indian practitioners together makes up 17,000 practitioners versus white practitioners of 18,000. So there's a disconnect. So what I did was, when I was attending a BRICS Law Summit in 2018 in Cape Town, and at that BRICS Law Summit, of course, it involved Russia, China, Brazil, India, and South Africa, I was shocked and alarmed to see the absence of women lawyers, firstly on the panel, and then secondly, attendees. On the panel, there was only one woman. She was from Russia and she couldn't make it. The other person was Janine Myberg, but she was called to chair the meeting. And in a breakaway session, I had noted that in that particular breakaway session, we were about 60 candidates sitting in that in that meeting, and there were only 3 women. And that began the light bulb started flashing that I can now understand why women are complaining that they are not getting the work, because they're simply not visible. And that then led me to create platforms for empowering and training women to be recognized and to and also for nomination to the judiciary when positions come up. I've used that voice in each and every board that I serve on, that's before each and every commissioner. For example, at the South African Heritage Resources Agency, there we are concerned about recognizing the heritage, the rich cultural heritage of our indigenous people in South Africa. I'm the only woman serving on that board. And when I asked the CEO and the chair, how is it that I am the only woman amongst all these men in 2023, I was told women do not apply. So, we sit with those very niche areas in law, which are areas in law which are going to be dominating, I believe, our legal landscape going forward. Connected with that, South African Heritage Resource Agencies is, of course, the tangible heritage and the intangible heritage. And I'm more concerned about that intangible heritage that we've not covered. Coming to perhaps the South African Geographic Names Council.
No, let's not get there.
Thank you.
I just want to know what will happen to your directorships in these bodies if you are appointed.
Yeah, I've always imagined, I need to just premise this with this first. I've always wanted to be an entrepreneur. A position of the judiciary was never on my horizon, I must be honest. In 2004, when I had the taste of it, it was still not on my horizon. I enjoyed it, but I couldn't see myself. I felt I was too young at that point in time. So I saw myself as being the foremost women-led law firm in the country. Part of that dream came true in 2019 when I expanded my footprint out of Cape Town to Kimberley and Gqeberha. Unfortunately, that didn't last very long. So that was always my vision. But I'm mindful that as time goes on, we develop, and I think I've done my fair share of running my business. I've mentored many through that practice, besides mentorships outside the practice. And I do believe that a new challenge is where I should be, And if I can add to the rich jurisprudence of South Africa, perhaps developing the common law in terms of all my heritage experience, I believe I would then be making my mark. So I'm quite happy to hand over the directorships. I have able people who are able to take it forward. I must just add that to serve at the Western Cape High Court from April to date means that my practice still continues. Of course, I have no connection with my practice because I understand what my ethical responsibility is as a judicial officer. So I've developed other people who can then take over the reins if I am successful.
All right. Acting Judge President Goliath.
Thank you, Chief Justice. Mrs. Parker, you've been acting at the Western Cape High Court for some time. How did you find the experience and the support provided by the judges in the division?
Thank you very much. I firstly need to say that it was a very different experience. 2020, I can't compare 2021 because that was, I did the entire, all my matters were heard virtually. But if I compare 2023, 2024 to 2004, it's a completely different experience to 2004. And I need to say that because way back in 2004, there were very few people of color at the Western Cape High Court. I could not walk into a judge's chambers and get advice or direction. There were very few women, probably only 3 black women at that point in time. Come 2023, I knew some of the judges, some that came a long way, and then, of course, there was a range of new judges. I understood what the protocols are in terms of me coming in as an acting judge. I would go to the judges and introduce myself, tell them that I'm new in the division. I've always been welcomed with open arms, AJP. I've never had any the slightest contestation from a judge in the division. And then secondly, the AJP, you've always told us in our judges' meetings that you've got an open door policy. And you know I make use of that open door policy. And you gave me a time. You said 9:30 any day, anything that troubles you, anything that you are concerned about so far as work is concerned, please come. And I've definitely made use of that opportunity. And I thank you for that because there were 2 instances specifically, AJP, that I came to you when I had a conflict of interest in a matter. I've never returned any matters that was allocated to me. Whatever was given to me, I have done. In terms of the tea room, so going back to 2004, there were stories about nobody wanted to go to 2004. Nobody wanted to go to the tea room. I did go to the tea room in 2004, and I was viewed as an attorney, not an advocate. So the respect just wasn't there for me as an attorney. Unfortunately, it prevailed at that point in time that elevation to the bench was through the bar and not through the sidebar. Be that as it may, in 2023, 2024, I went to the tea room and I was pleasantly surprised to see the mix, the diversity of judges and acting judges that were there. And I would use that opportunity to bounce off a niggly point just before going into court. Other judges, I would make time with them and then I would go to their chambers. Nobody has ever turned me away, and I'm thankful for that collegiality.
How did it happen that WOZA Awards or WOZA Leadership Academy was established?
Yes, so that was born out of the BRICS. Sorry?
Before you answer that question, Ms. Parker, I don't mean to put you out, but I'm going to have to ask you to try and keep your answers as short as possible. We still have 3 other candidates to interview, and I'm told that they have flights to catch to Cape Town, some to Cape Town and elsewhere, today still. So
I'm one of them, CJ, so I will definitely bear it in mind. WOZA was born out of that BRICS Law Summit. I had the first WOZA Awards in this very room, 2019. where we recognize the trailblazers and the change makers in the profession with the aim of unearthing the phenomenal women in the profession. We recognized key people like Advocate Komoto Romoto of the Senior Council, as well as Priscilla Jana, the late Victoria Mkenge, and after that we then had another Woza Awards across Africa, where we brought judges, practitioners, academics all together. And it was a wonderful space. We've had absolutely a wonderful feedback from that, saying that women, it has elevated their status in people didn't know that they existed before. So Woza was born primarily out of that. But out of that, we saw the Woza Leadership Academy, which I think became the hard work that brings me to today, where we realized where the gaps and the shortfalls are so far as women are concerned, and we provided training, free training, nurturing, mentorship, and at present we are busy, we've just concluded an MOU with the IVA, which will be rolled out to the profession very shortly, on policies, workplace policies, sexual harassment. That survey should be rolled out by November. We also have, together with the University of Johannesburg, SAC IAWJ, and Belinda Mapungwana, an attorney, were successful in receiving substantial funding for gender diversity in the profession, mentorship, workplace readiness, and then to influence policy change. So there's going to be a lot coming out of that, Acting Judge President, in terms of the implementation of that project. The funder is outside South Africa.
How did you cope with the workload at the Western Cape Division? Did you manage your workload?
Yes, I managed it fairly well, I would say. I could manage a motion court with ease. At first, I thought, how am I going to get through 63 matters? But I got through it. I've managed I've never turned a matter away, and none of my judgments have been longer than 6 months. On average, it is about, I would say, between 2 and 3 months. There was only one judgment that was 5 weeks and 1 day, and that is because it was a long duration trial. It was given to me in the the third term, my first acting stint in 2023. It involved 52 plaintiffs. It was a taxi association matter, and I heard about 46 plaintiffs. So I took my time in writing that judgment because I knew whether I'm writing it for the plaintiff or the defendant, it was going to be appealed. And that matter is, I'm keenly awaiting the outcome of that matter, Chief Justice, to see whether my decision was sound or not.
Thank
but
you,
I did
Chief
manage.
Justice.
Thank you.
Thank you.
Mr. Boshoff?
Thank you, CJ. Good afternoon, Ms. Parker.
Good afternoon, Commissioner.
So the Western Cape Division has quite a heavy administrative law caseload. And I would just like to ask you some questions dealing with administrative law. A company concludes an agreement with a municipality in terms of which it agrees to sell land that it owns to the municipality. It then later transpires that the municipality, there was no council resolution in compliance with the Municipal Finance Management Act, confirming that it had the available funds, etc., and therefore alleges it's not bound by the agreement. Can that private party, the seller, rely on the principle, or can it rely on estoppel or the so-called Turquoise rule to say, look, it's not, in order to enforce the agreement, or alternatively to say, well, it's perfectly entitled to assume that the municipality complied with its own internal prescripts, etc., and therefore they must remain bound to that agreement?
Yes, that presents, if it's a municipality, it would present itself with administrative action, I would think. And I would think that in terms of the PAIA legislation, which is a statute in terms of Section 33, everyone's right, everyone's right to a fair procedure, a reasonable and lawful action can be taken via the PAIA route, certainly. So I would see that, yes, I would think that definitely that would be a route to follow. Yes, that is what I think would be the route
Perhaps,
to follow.
mate, let me just clarify. So the question is whether the seller can say, I note what you say, municipality, but we're going to court and we're telling the court, hold the municipality to the agreement, I'll hold them bound, notwithstanding the non-compliance. And we're relying on the concept of estoppel. Or alternatively, as a variation there of the Turquoise rule, we're invoking that to say, well, we are entitled as an innocent outsider to assume that the municipality, when they contracted with us, we assumed in good faith that they complied with their internal prescripts and statutory responsibilities, and therefore you must hold them to that contract.
Yes, I think that the applicant would be able to bring an application to court to call for the enforcement of that contract.
Okay.
Sorry, Chief Justice.
Yeah.
I do want, because I don't want to come back to this. To simplify the question, you understand the take-on rule and the doctrine of estoppel.
Yes, it means that I'm relying on the doctrine of estoppel to.
I'm saying what they are, what they mean.
I can't offhand. It will probably come back to me in a few moments.
All right, no, that's fine. Now, the question from Mr. Boshoff, from Commissioner Boshoff is, can the municipality be bound to an act which is ultra-virus by the application of the doctrine of the take-on rule or estoppel?
Yes, if the municipality's decision was ultra-virus, then that contract that it tried to procure with the seller would not stand.
And why not?
Because the decision the relevant resolutions was not passed at the level of the municipality, and the decisions that were made administratively were done ultra vires.
Sorry, Mr. Boshoff.
Are you covered?
Yes.
Thanks, Commissioner. Then just a non-administrative law, just a general kind of civil procedure question. What do you understand to be the current test when faced with a question of the appealability of interim orders?
I think it's the Lubashe. I might have the case wrong, but it's the Lubashe. Generally, the interim orders are not appealable. That I know. However, if it's in the interest of justice, and I think that was the Lubashe judgment,
Yeah, thank you.
and I think that has saved so many applicants who were seeking interim relief now finally have another life in terms of the Constitution.
No, thank you. You've got it. Thank you very much. Thank you, CJ.
Commissioner Matolo-Lebu.
Thank you, CJ. I just wanted to declare that I know Ms. Parker for years. We've been together in this journey. And when she mentions a person in this room who has been awarded by WOSA, she's talking about myself. I think she was afraid to name me. I thought so we have been together for years, working in gender-related issues. That's my declaration. Thanks.
Thank you,
Commissioner-
CJ. That is correct, and it was in this very room, Commissioner Lepu. We go back to the IBA in 2003, when Judge Navi Pillay was, I think, the International Criminal Court Justice.
Commissioner Shabangumdawu.
Thank you, CJ. I also want to declare that I know Ms. Parker. She's assisting in a number of our projects. Good afternoon, Ms. Parker.
Good afternoon, Commissioner and Madam President of SAULA.
Yeah, your contribution towards transformation and empowerment of women is known in the legal profession. And we do have a problem that when people who are active in transformation, immediately when they are sent to the bench, they forget about it. So you, if appointed as a judge, what plans do you have to make sure that the promotion of transformation and empowerment of women still continues, and make sure that there's access to justice to the poor people?
Thank you very much, because that's a question. Access to justice is at the heart of what I do, Commissioner. Very importantly, I've already set the ground for the future, irrespective of whether I get this position or not. The one project with the University of Johannesburg and the SAC IAWJ is an example of how I am involved in transformation, irrespective of whether I get this position or not. I'm also currently involved with the production for TV. I know this is unusual, CJ, but I wake up some mornings very early and I come up with bright ideas. And this bright idea was sprung during the recess in March, and I wrote a proposal to television to do a production on access to justice. And I've been invited to be trained on becoming a producer. So I have, it's something that transformation is at the heart of what I do. I believe that we've got to rectify that gender disparity that we have within the profession and the skewed numbers that I referred to earlier, and that we need to ensure that the barriers to the profession are eradicated. Perhaps not eradicated, but minimalized. And as one ascends that ladder, and Chief Justice, I think you were present at the Constitutional Court where the Institute for African Women in Law launched their report and spoke about the bottom rung, that bottom rung needs to be fixed before we can accelerate to positions of leadership. So my transformation would continue. If I'm appointed as an acting judge, believe me, I would continue. There is one aspect where I have already started thinking. I was approached with regard to the training of judges, because aspirant judges, because there's a problem that we have, and I hope the ministers here, I can't see so far unless I put on my spectacles, that many women would want to be trained to be judges. However, they cannot afford to leave their practices to attend training. That's problem number one. Problem number two, that the training that is available to them, I think it's only done over 2 to 3 days. Acting Judge President, you would know. And that is certainly not enough. You can't train an aspirant judge in 2 to 3 days. Yes, I was one of those products, but I do believe that it needs to be a funded project, and that stipends need to be paid for aspirant judges. Then we're going to get more women. What are we currently sitting at the judiciary? 282 men judges versus 115 women judges. So the scales are definitely not up. So a short answer to you, Commissioner, it's work that will always, it will always be under construction and in progress.
Thank you, Ms. Parker. Thank
Professor
you, CJ.
Marumachai?
Thank you very much, Chief Justice.
Sorry, before you have a bite, Prof, there's a follow-up question from JP Mlam.
Ms. Parker, I just wanted to correct you. The Women Aspirant Judges program is year-long. It's not 3 days.
Yeah, yes, perhaps I'm incorrect. I was referring to the training that where aspirant judges are invited to be trained, and I've always seen it as being over a very
there's
short
one-
duration.
There's one
Yes.
that happens
Yes.
every January, but that one is both women and men. The Women Aspirant Judges Program is year-long.
I was not referring to that one then, JP Mlambo. I was referring to the very short duration. It's wonderful that we have those platforms, but women can't leave their practices, and they need to pay for their flights and their accommodation. That is what I was told when I suggested some candidates to go for judicial training. But I will accept the longer program that is offered, and that's wonderful.
Professor Marumake?
Thank you very much, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
My first question is in relation to the debate that you had with some of the commissioners with regard to the Taekwondo rule. I was a bit confused, but I see that this is the issue that came before the Supreme Court of Appeal and the Constitutional Court, and in respect to municipalities. And my question is, I mean, I've just seen briefly what these two courts have said, but I just want to understand from your side, because the Constitutional Court is saying that Taekwondo rule is a subspecies of estoppel, right? And they provide a reason why they are saying that. Can a Taekwondo rule, either in its common law understanding or in its sort of codified form, in as far as the Companies Act is concerned, be used in the context of municipalities? Like if we understand it as a proper common law rule, is it something that can be used? Because the defendant, the people in this case, they were saying, no, actually we should take lessons from how it is used. But can it be used in the context of municipalities?
Commissioner, if I'm going to venture an answer, then it's going to be guessing. So let me rather not do that. And believe me, that's the first thing I'm going to do when I leave this room, is to go and read up on the Turkish rule.
No, that's fair enough. My second question is, and I think it is important sometimes to really assess the candidates who wants to be judges with respect to the uniform rules.
Yes.
And really get a sense of how especially the most popular ones, because this is not an exam really to test whether you know or you don't. Just want to see as to whether some of the tried issues are on the person's fingertips. Normally, in various divisions of the High Court, a lot of matters are brought on an urgent basis. Sometimes we hear words like semi-urgent. So there are always those kind of distinctions, but the rules, when you look at them, it's like a matter is ordinary or the matter it's urgent. I just want to understand what is the test for urgency, because sometimes you go to court on an urgent matter and the judge says, no, this is not urgent. Sometimes on the same facts, another judge says this is urgent. What is the actual test for urgency?
Thank you very much for that question. It's a very important question, because if you sit in the motion court and urgent courts, that's always foremost in your mind, Rule 612B, that the founding affidavit must specifically, clearly set out what renders the matter urgent and why substantial redress cannot be made in due course.
Okay. No, thank you.
Thank you.
Thank you, CJ.
Commissioner Moimang?
Thank you, Chief Justice. Greetings to yourself, this side.
Good afternoon, Commissioner.
Just one question from my side. From your observation, does the Constitution stand in the way of land reform? Or do you think that there is adequate provision, or do you think that it makes space for adequate provision for judicial control to ensure that there is equitable redistribution and restoration of land?
Sorry, Chief Justice, if you can just repeat, I couldn't hear the last part clearly.
Are you of the view that there is enough space in our Constitution for judicial control to expedite the issue of land redistribution and land restoration?
Yes, a very, very
Thank you.
important question. Land is always close to people because our identity is inextricably linked to land. The Constitution makes provision in terms of advancing people's rights to land. And there are various provisions if we are talking about in the domain of land claims or ESTER applications or labor tenants. Yes, there is a mechanism that's very much in place for land claimants to assert their rights in terms of them having been dispossessed of their land or of their rights if they were labor tenants, and the same goes for farm workers. I think there is enough. We battle with issues with regard to, firstly, getting landowners to acknowledge that there was a dispossession. That I've been involved with, so I'm fully aware of the difficulties that one has with that, and that is specifically related to the compensation, the difficulties that one has with landowners pushing for market valuations rather than looking at and understanding that land reform is to redress the inequities of the past, that when the land was acquired, it was acquired in terms of a particular apartheid policy, where a tract of land was given to Mr. X with a land bank loan at favorable interest rates, and then we grapple. So through our jurisprudence coming through the land claims court, there are cases that deals with land reform in that respect, and I think that we can't even. There are several other land claims where people still wish to make claims, but they cannot because of the judgment that was given down by the Constitutional Court that the backlog cases first need to be adjudicated on. There's only so many judges that hear those matters, and perhaps if we could capacitate the Land Claims Court with additional judges, I think then we would be able to get our citizens more satisfied. But the longer we take, and more people die before they see their land or their compensation, I believe does us an injustice.
Thank you, Rohit Parker. Thank you, Chief Justice.
President Molemen.
Thank you very much, Chief Justice. Good afternoon, Ms. Parker.
Good afternoon. I just got.
Oh, yes.
Sorry. Thank you.
Okay.
Thank you. Good afternoon, Commissioner.
Yes, I'm looking at your questionnaire, and I see that you state that your exposure to criminal litigation is 5%.
Yes, that was now. It's not. Yes, I think it is 5%. Yes, no, correct.
Yes, so
yes,
as
correct.
at the time you completed
yes,
this
it is
form,
5%.
Yes, your proportion of litigation, criminal law litigation was 5%.
That's correct.
And I think you indicated that you conducted only 2 criminal trials throughout your acting stint. Is that correct?
That is absolutely correct. 2004, I did 2 long-duration criminal trials, but in practice, recently, 2022 to 2023, I was back on the Legal Aid Board's panel. I did criminal work, and historically in my practice, I would pick up private clients who, and that's what the 5% reflects.
Yes, I'm talking now in terms of what you have done while acting as a judge.
Only 2.
Only 2.
Besides criminal appeals. And
Yes, I'm
yes.
talking about criminal trials.
Only 2.
You have attached a judgment here, but the judgment that you have attached is only on sentencing.
That's 2004. Records are not available. I tried to get a list of all my cases, which I did in 2004. That is what we could find on SAFLI because it was marked as reportable, and that is all that it shows on there. We have been trying through my registrar at the division to go and access the archives because I was keen to see my various judgments, which I cannot add to my judgment list, which I did in 2004. Unfortunately, it was before the capturing of the digitization as it's done now. Unfortunately, it's lost.
The concern that I have is that you say that your exposure to criminal law is only 5%, and then you attach only one judgment, and that judgment is also only on sentence. So how do we now fairly assess whether you will be able to cope with the conduct of criminal trials, especially considering the fact that AJP Goliath indicated yesterday that most of the cases in that division concern multiple accused, and as a result, they are regarded as more complex. And the judgment, the one judgment that you have attached relates to a single accused.
Sorry, yes, my apologies. I could not find, my registrar only found the second file, couldn't find the Waterboom one at all, except for what is on SAFLI, but she managed to find through the criminal registrar's section at the court, or the criminal clerk, my second my second criminal matter which I did, and she found it purely because that matter went on appeal. So she gave that to me last week, and that full judgment together with the sentence is now in my possession.
It's not before us.
No, I was not aware that I could supplement my papers, Commissioner. If I had known that, I would have sent it.
I hope you understand my concern, because I think you'll agree that criminal law is a very important aspect of the law, because eventually if you sentence a person to imprisonment, you have taken away their liberty.
Absolutely. I fully agree with you, Commissioner.
Okay. Under what circumstances would you go into would you order that you go into a trial within a trial?
Yeah, a trial within a trial in a criminal context?
Yes.
Yes, that is where there would be, a trial within a trial, I would think would happen in the instance where certain allegations are made against the co-accused, and then I would have to hear that specific issue. Yeah, I'm not exactly, perhaps my answer is not correct. Let me not guess it. Thank you.
Thank you very much.
Can I follow up,
Thank you,
CJ?
CJ.
Can a criminal trial, a trial within a trial be conducted in any other context than in a criminal trial?
No, I've never seen it happen in civil matters, but I'm aware of it happening in criminal matters.
Oh, no, I was just responding to...
Yeah, no, I'm thinking
Okay.
clearly now, so only in criminal matters, yes.
All right. JP Mlambo.
Good afternoon again, Ms. Parker.
Good afternoon, JP.
In your acting stint, have you ever sat in a full court and scribed that judgment?
Yes, I have. I have done in an appeal, yes. I've done it in 4 matters, of which 3 of the 4 I was the scribe.
I see, okay. Do you understand the, the plus-con-evens rule, and under what circumstances is it applied?
A very important rule in motion proceedings, that an applicant would be granted relief when a respondent admits the averments made by the applicant in its founding affidavit and does not contest any of those averments. In those instances, the applicant will be successful So it's the admitted facts in the founding affidavit together with, where the respondent admits the facts in the founding affidavit and the uncontested allegations made in the founding affidavit. If that is the case, then, only then, in terms of the Plaskon-Evans rule, will the finding be made in favor of the applicant.
There was another follow-up hand. Who was it?
No, CJ, you asked the question that I wanted to ask, so I'm
All
covered.
right. Is there follow-up? Okay. Commissioner Nkaito?
Yes, thank you. I did have a different question, but I do need to explore the Plaskon-Evans understanding. Because I'm not sure if it's about granting relief or whether it is about resolving disputed issues, or whether you appreciate the distinction.
Yes, it's about resolving the disputed issue that I will find in favor of the plaintiff if the averments
There's no plaintiff.
I mean,
in
by the
Plaskon.
applicant, sorry,
Yes.
my apologies.
Yes.
If the averments,
So you mentioned one where the facts are common cause, but that's not where Plaskon-Evans applies.
no,
So then,
It's-
where does it apply then?
it applies in the instance where the respondent just has not made out a case has not responded to the facts as found in the, by me in the applicant's
But
affidavit.
that's where the facts are common cause. So applicant says, this is what happened. The respondent says, I admit that that is what has happened. So that's common cause.
Yes.
So I'm talking about where there are disputes of fact. How does the Plaskon-Evans rule apply?
Yes, when there's a dispute of fact, then, I would not be able to find in favor of the applicant in that circumstances. I would have to consider whether I need to refer that matter to oral evidence on perhaps a specific issue with regard relating to that disputed fact. I could also give directions with regard to how that oral evidence should be heard and who should be subpoenaed. Of course, I can grant absolution from instance as well. That's what comes to mind.
Grant absolution in an application?
No, not in an application, no.
All right, anyway, let's move on. That was not the question I had raised my hand to ask. I was taken aback when I saw the comment by the GCB that there was a day bonus, a personal cost order against you. I thought it's GCB. All right. I'm corrected that it's the AFT, not the GCB. I thought it was the GCB.
It is the GCP Commission.
Yes, all right, then I'm correct. That there was a personal cost order against you in 2019, which you did not disclose when you applied, when you had a duty to disclose it. Can you explain why you did not disclose it?
It's an error of judgment on my side, and I apologize profusely for that oversight. It didn't even cross my mind at that time when I completed this application form. So I am grateful to the General Counsel of the Bar. AFT also mentioned it in their response that I ought to have disclosed it. But in terms of the question that was asked on the questionnaire, I did not regard that order against me, that I was in any way dishonest. It could happen to anyone. It happened in my practice, which is unfortunate. I took responsibility. I acted on it. I paid that debt, and I put remedial action in my practice immediately following that judgment.
No, I'm just asking about why
Yes, why I did
you
not.
did not disclose it. That's the first concern of the GCB.
Yes, I apologize. I should have disclosed it. I didn't. In hindsight, it was my error of judgment, probably because I didn't regard it as damaging my reputation. I didn't regard it as bringing the judiciary into disrepute. Commissioner.
The second thing I was taken aback by is how you explain the basis for the de bonis, because you say it was because you failed to index and paginate, which then forced me to go to the Ebenheiser judgment to read why you were mulcted with a personal cost. And I realized that what you said is an under-disclosure. It is a series of lapses in litigation against a series of notices that were given to you by Judge Mir, which you ignored. It was not just failure to paginate an index. And I'm very worried about what you did in your response to the GCB, because it seemed to me you were still not taking responsibility.
I think I did, with due respect, if you look at, Commissioner, if you look at my response, which was very short because I only received these comments a day before the closing date. I'd said it was a lesson learned which made me stronger and more vigilant in my supervision of staff. I respectfully submit that it was a human error, which is regrettable. I can assure the Commission that this experience will not detract from my judicial duties in any way, and that since the order was granted, I have put strict controls in place with my staff and took the necessary remedial action. That lesson has made me a better person.
No, the problem is the explanation you give why there was a personal cost order is paragraph 6, where you say the pagination and indexing were not done timeously, which led to Judge Mir granting an order against me. That is what I have a problem with. The explanation you give why there was a cost order does not tally with the reasons in the judgment why there was a personal cost order. An index and a pagination ordinarily, in fact, I thought this is an unreasonable judgment because a failure to index and paginate would not attract a personal cost order, which is why I went to the judgment and I saw that actually this statement is an under-declaration because it is a series of lapses against a series of warnings that led to the personal cost order.
It's regrettable, Commissioner. It's an unfortunate phase in my practice. First time it happened in so many years.
No,
And I
but
wouldn't
it's the explanation you are giving to us that I'm worried about. Because I can understand that in your practice you will make a mistake. I've made many mistakes. But the issue is you are now before us, you are called out on it. And the way you are responding to it leaves me very, very worried.
But perhaps if I can reply that I was given very little time. I was told that this was due, I think it was the next day or the morning when I made the decision. First I was told that this was not an objection, it was a comment and that I did not need to respond. I then wrote to the Secretariat and said, "Are you sure?" Secretariat came back to me and said, "Yes, we normally only write to candidates and call for their response if it is an objection." I slept on it. I woke up the next morning and I decided that I still needed to address it, which I did in the morning, and this was then sent off. Perhaps I should have been more, perhaps I should have elaborated in more detail, which I did not do, and I also apologize for that.
Thank you, Chief Justice.
Just a follow-up on
Yeah.
part of your exchange with Commissioner Ngugaitobi. In what kind of proceedings and in which circumstances may absolution from the instance be granted?
Absolution of the
From
instance?
you mentioned absolution from the instance.
Yes, in civil matters, when the plaintiff just had no case before me, I would grant absolution from the instance.
All right, thank you. Minister?
CJ, so I just have a follow-up on the exchange with Commissioner
All right.
Ngubatobi. Ms. Parker, sorry, Commissioner dealt at the end quite extensively with your under-disclosure, but I'm equally concerned about now having had the chance to reflect on this. You still seem to play down the severity of such a cost order. I mean, it is commonly known as one of the most dismissive actions a judge can take in showing not disfavor, but disdain for how matters were conducted before it. It's not something that's issued because somebody filed papers a day late, or it's usually done and reserved in the most extreme cases of legal, I suppose, delinquency. And I'm concerned that you downplaying that is also, I don't know what to make of that. And I would just like to, well, I suppose I'm pointing it out, and you're free to reply to that.
CJ, I have a related follow-up.
May I follow up on that? Yes. Ms. Parker, good afternoon.
Good afternoon.
I thought she was still answering.
I'm doing a follow-up on that.
Had she answered already?
She hadn't yet started.
Oh,
I just wanted to, so that she answers once.
Okay,
Maybe I'm
okay.
being inarticulate, I'm sorry.
Okay.
I'm sorry. Yes, Ms. Parker, perhaps just to complete the picture, you were punished with this cost order, de bonis, because of a postponement of trial that was set down for 3 weeks. So it was a serious matter. It wasn't just filing, it wasn't ignoring notices. I've had a look at the judgment. The matter had been set down for 3 weeks according to the judgment, and it had to be postponed because it wasn't trial ready. Now, the concern from your declaration, but also your responses now, is there seems to be a lack of candor over and above the concern of you seem to default easily to, well, I paid, I put in place systems in the office, but the fundamental issue is the appearances of lack of candor in your disclosure about this and whether you appreciate the seriousness of it. You may comment if you want to.
I do appreciate the seriousness of it. If I had been more prudent, I should have included it in the first place when I had applied to the JSC. I should have then addressed the full issue with regard to how the order was made against me, and I should have also addressed the issue with regard to the acceptance that it is my error emphatically. I didn't do so, and I cannot take it any further than that, except to say that on the day, the matter was going to be set down for January, end of January, and a few days in February. It wasn't for 3 weeks. However, when Judge Meer had called for a meeting to discuss the fact that the files were in a disarray, at that stage, I did have issues with my service provider, including the state attorney, who did not give me mandates timeously. Judge Meer in the judgment said I should have brought that to the attention of the court. At that point in time, it was very difficult to tell a judge that the person that's giving me instructions aren't giving it timeously. I had, in the period December to January, lined up the cultural historian, the valuer, the agriculturalist, the actuary as well, to be able to get the matter trial ready. However, it was the landowners who rightfully complained that the files were in a disarray because the indexes just didn't match their papers, and we are talking 47 volumes. I've accepted the responsibility for it. When the judge president had postponed it to the 18th of April, I think that was the date, she had asked me to please file an affidavit, which I did, setting out the difficulties that I had and the challenges. That was not acceptable to Judge Meer, and I accepted that. I immediately told my clients that I would not be able to act for them any longer. And a new service provider was then made a provision for. I handed over the files, and within a month later, the issue of dispossession was settled. And I would like to believe it's that hard
CJ,
work.
Commissioner Hassan, apologies for the interruption. I think There's just, it's an important follow-up because it is related, Ms. Parker, sorry, over here, to paragraph 54 of the same judgment where AJP Mir says, in my view, the conduct of Parker substantially materially deviated from the standard expected legal practitioners, etc. And it talks about a serious dereliction of duty, which prejudiced all the parties. So I won't read that whole paragraph, but I think it's important to emphasize that. And also, you're speaking now, Ms. Parker, around what happened after. In paragraph 9 of your response to the comments from both AFT and GCB rather, you said you were, however, relieved that when you learned that the matter was settled shortly after the order against you, and you'd like to believe it was the hard work you put in regarding the appointment of experts who saw it come to fruition. And I have a concern with that statement because I think it does lack accountability. I accept the argument that you've been making, but to say that in a response almost says, well, even though I did this really terrible thing, even though there's paragraph 54, which is extremely damning from a very senior judge in the country, and then to say, well, it was settled shortly because of my hard work, I do have concerns with that. And I really wonder if your remarks, I mean, do you think they have an impact on your reputation, on your integrity? Thank you, CJ. Sorry to have interrupted.
I didn't, yeah, perhaps I should, I put in the paragraph 9. Paragraph 8 and 9 was basic, it was basically just to reflect on what I had put in. I accept I should have, perhaps my error that I did was just to give this response was too brief. It should have had far more meat to it. Particularly that I received the objections, the comments so late. As bringing my reputation into disrepute, and I think it stems from that. If that is how it is viewed, and I agree with Commissioner Bishop, it is a serious order, but I didn't see the connection with it bringing my reputation into disrepute. I accept that the negligence was, as a result, was in my hands.
Minister?
Thank you very much. Good afternoon, Ms. Parker. I just want to check in the letters of support, there's Khoi Cultural Heritage Development, which says you have played a pivotal role in the achievement of something. It's not fully descriptive, but with regard to Norfolk Skral community. Are you assisting the community and how?
Thank you very much, Commissioner. Yes, I am. It's still a matter which is at my firm, of course, because I'm acting. I cannot be the legal representative, so I've given it to another person in the firm. When I'm done with my acting stints, I would go back and be the legal representative. That's an action which I've defended against an eviction of several families. It's called Knoffelskral in the Grabouw area. Where I defended the case, where I am, my firm, well, I defended it, but now, of course, I'm acting, I can't be involved in the matter, so I'm referring it as I'm defending that community against the Department of Forestry and Fisheries. It's sub judice at the moment.
Okay, I was asking it understanding that it is sub judice, but I just wanted to understand the role you were playing and you are possibly playing now. In light of the very same, and maybe if you could be able to differentiate time-wise for commissioners, when did you start to assist and when did you cede to another? So one is certain that there is no cross roles that you are playing in this matter, at least.
Thank you.
So I don't want the substance of the case.
No,
I just want the procedure and the process. Yes.
Commissioner, I would never, I will be failing in my judicial duty to sit as an acting judge and still consult with clients and draft pleadings. I don't do that. This case came to me before I became an acting judge, where I was asked to defend communities in Knoffelskral. They intend to bring the land claim in due course whenever the Constitutional Court is satisfied that the backlog is done and the gates can be opened for new claims. They were faced with eviction. They believe that this is their ancestral land. They're in indigenous Khainakwa tribe, Commissioner.
Chief Justice, I'm sorry to sound like when did you start acting? And when was the case referred?
The case was referred probably at the beginning of 2023, and I only started acting in July 2023. When I acted the matter, all pleadings would be signed by the new attorney assigned to the matter in my office. And where I do not have, sometimes, for example, in another matter which is in our court at the moment, also an eviction matter with constitutional law points, when I took the acting position, when I was invited to act again from June this month, I had to quickly ensure that I got another person in my office to attend and consult with the clients and prepare the pleadings. When that particular practitioner was going to attend her daughter's wedding in the UK, I managed to speak to other law firms so that they could be empowered and have exposure in the kind of constitutional law points which I'm raising in that case. So I would always ensure that somebody else would run with the matter when I'm acting on the bench, Minister.
So do you think I'm wrong if I'm assuming that the matter was in 2022?
Could be 2022, yes. But I was not acting in 2022. I acted in November 2021, Minister, and then as from June 2023, and then intermittently till today.
All right, it's okay. Thank you, Chief Justice.
Thank you, Minister. Commissioner Baloyi, you covered.
I did my bit, yes, thank you.
All right, thank you. No further questions. All right, thank you, Ms. Parker. You're excused.
Thank you very much, Chief Justice and Commissioners, and good afternoon to everyone.